Right, welcome back to the Licensing Subcommittee decision. Yeah, I'm good. Thursday the 10th of July at 12:30 in the matter of the Licensing Act 2003, application for premises licence Chantel's Lounge, 70 Elm Grove, Southsea, PO5 1LN. Decision. The subcommittee has considered very carefully the application for a premises licence at premises known as Chantel's Lounge. It gave due regard to the Licensing Act 2003, the licence objectives, statutory guidance and the adopted statement of licensing policy. The subcommittee considered the relevant representations, both written and given at the hearing by all parties. Human rights legislation and the public sector equality duty has been borne in mind whilst making this decision. The application relates to a proposed cafe bistro, previously a dress and fabric shop, and is for the provision of retail sale of alcohol for consumption on the premises only between 11 o'clock and 2300, 7 days a week. The applicant had agreed conditions with the police in relation to there being no provision for vertical drinking, no standing area for alcohol consumption, and no planned live entertainment. The subcommittee noted that there had been representations from 6 residents objecting to the grant of the licence due to concerns about crime, disorder, drunkenness and public nuisance, including noise escape. It was noted that no representations had been received from any of the responsible authorities, notably the police or environmental health. The applicant had contacted the objectors via their agent in an attempt to resolve the objections prior to the hearing. After having heard all of the above evidence, the subcommittee determined to grant the proposed application, subject to imposing conditions proposed by the applicant and agreed with the police. Reasons. Objections. Oh, I've gone too far. From residents focused upon the number of existing licensed premises, a potential increase in nuisance and disorder if another bar is permitted, and the potential for non-compliance with regulation, particularly regards installation of the premises, given other non-licensing issues existing drunkenness, disturbance, property damage, including to a nearby bus stop, public urination and violence were raised in relation to what is stated to be a saturated environment. The subcommittee noted that commercial need for additional premises could not be considered. Also, that private issues regards to lease terms or planning permission, building control approval are not licensing conditions. The subcommittee heard on behalf of the applicant that the premises is not a bar but is in fact a cafe bistro offering seated table service of food and drinks throughout the day. Further, that there is to be no provision for vertical drinking, no standing area for alcohol consumption and no planned live entertainment. CCTV will be installed, staff will be trained, a Challenge 25 policy will be adopted, under 18s will not be permitted at the bar, a register of refusals will be maintained and any instances will be recorded. These points had been agreed with the police in advance of the application, meaning agreed conditions shall be added to the licence to enforce these points, save for live recorded music, which are exempt in accordance with the Live Music Act 2012, amendment of the Licensing Act 2003. The subcommittee accepted legal advice that evidence submitted and relating to other premises and applications nearby is of no relevance to the application being considered and accordingly attached no weight to that material. The subcommittee balanced that the interests of the business, noting the steps outlined to address concerns against concerns of local residents relating to potential issues, and determined that it would be appropriate to grant the licence subject to the conditions to be attached to the licence. This is considered a low-risk proposal in light of the fact that there is a food-led and there is to be no provision for standing consumption of alcohol. The hours applied for are what would be expected for such a premises and not a bar. It was noted that no representations had been received from any of the responsible authorities, notably the police or environmental health, and that a lack of representation had to be inferred as no objection being held. The statutory guidance being clear that each responsible authority is usually the main source of advice for their respective field. Residents can be reassured that in the event that the licence does not result in issues undermining licensing objectives or the business does not operate in the manner or style asserted and this results to the licensing objectives being undermined, the licence can be subject to a review or conditions imposed, licensing activity restricted or ultimately the licence can be revoked. It was clarified during the hearing that outside tables and chairs would require authorisation and this would be unlikely to be granted due to the space available. There is a right of appeal for all parties to the Magistrates' Court. Formal notification of the decision will be set out, that right in full. And that concludes today's subcommittee. Thank you.